Meeting the individual needs of students with disabilities is a challenge. Sometimes parents and schools disagree on what is necessary to provide a fair and appropriate education for the student with special needs. Communication can break down, resulting in a deadlock. This deadlock can lead to frustration, damaged relationships, lost educational time, and money. Meanwhile, the individual losing the most is the person caught in the middle, the child.
What's best for my son isn't going to be the same for everybody else. He has his special things he needs.
Oh no, this parent thinks that I've done something wrong to their child. I'm not teaching him the way I should. I knew that couldn't be the case because he had been showing growth in my eyes.
They know that they're professionals in their field and they just think they know what's best for your kid, and a lot of times it's not the best thing for your kid.
A lot of times as a teacher, you don't think the parent is hearing what you have to say.
To assist the parties in resolving their issues, the UALR Bowen School of Law has developed the Arkansas Special Education Mediation Project with support from the Arkansas Department of Education Special Education Unit. Mediation improves communication and promotes problem-solving between parents and educators, and helps them work together to create well-tailored educational plans for their special education students.
Mediation is particularly well-suited to education and special education issues because it helps the parties to learn how to work together. There may have been disagreements, disappointments in the past, but the teachers and the parents and the administrators all want success for that student. It's a way to promote them working together, helping them to hear each other, helping them to develop trust, cooperate, understand better why the parent or the teacher on the other side is trying to do what they're trying to do for the student. It gets them on the same page.
We're often perceived by parents and districts to be biased in favor of districts, simply because we are the Department of Education. And so that's not a distraction that we wanted to have in this process. So we decided that yes, it was a process we wanted, but it needed to function independently of our office. We would support it through our funds and assist in getting information out about the program, but we would not oversee it, manage it, run it, hire the mediators, none of the above.
Special education means specially designed instruction at no cost to the parents to meet the unique needs of a child with a disability. The federal law that protects the educational rights of students with disabilities is the Individuals with Disabilities Education Act.
For each student with a disability identified under the IDEA, the district and parents develop a plan that guides the process of education for the student. This is called an Individualized Education Program, often referred to as an IEP.
From my perspective as an educator in the field, the role of mediation is to cause teams, IEP teams, but including the family and educational personnel, to work together to try and resolve the issues that they may have.
One of the things with mediation is really just having a full and honest and frank discussion about what's going to be best for the child with special education needs. And what I've found is that whenever people explore all the things that are out there, they discover something that's really going to work well for them.
A mediator is an impartial third party who is familiar with the laws and policies affecting educational services for children with special needs. The mediator is a facilitator who helps the parties communicate and understand each other. Together, they identify issues, think of alternatives, and find a solution that is agreeable to all.
Facilitator is just a fancy word for someone that doesn't have any stake in the outcome. They're just trying to help the parties to resolve their issues.
Generally, mediators are trained, particularly in our program with the Special Education Mediation Project. They're only experienced mediators that even apply to become special education mediators.
We then, with the cooperation of the Department of Education Special Education Unit, train them on special education law and policies. We also give them additional training in group facilitation because mediations among teachers, parents, and administrators are very different than one-on-one mediations between two parties.
The job of the mediator is to make sure that everyone gets an opportunity to say the things that they want to say and gets an opportunity to listen to what's said.
The people that participate in the mediations are generally the ones that have information to share about the student. So that'll be the parents, the teachers, school officials.
Certainly we want people to be there who can contribute to solutions.
A lot of times the mediator is usually the third spoke in the process because everybody else in the room knows each other. So what you do is you go in and you introduce yourself, and you set down kind of some ground rules, and then you explain to the parties that everybody's going to have an opportunity to say everything that they want to say, that the process is to allow everyone to talk and everyone to listen. People will be asking questions. They will ask questions of each other. The mediator during this process spends a lot of time listening to the answers, because what he's trying to do, or what she's trying to do, is to get the little pieces that the other parties may miss.
We get into the meetings, and the special ed people, they would answer the questions, but they would give so much information it'd be hard to get the answer out of this information.
The mediator's role is to be an interpreter. Sometimes there's different language that goes on. The school might have certain phrases that they use that the parents aren't familiar with. And the mediator really interprets for the parties what these things mean.
I think in some ways people are not aware enough of how easy it is and how user-friendly it is, a process. And in that regard, I would certainly encourage them to be more knowledgeable about mediation.
One of the goals of mediation in these particular mediations is basically to come up with a plan for the student with special needs and try to get everybody on board with that plan.
The mediator will facilitate the parties in resolving their issues. If an agreement is reached, the mediator will assist the parties in drafting an agreement in their own words. Currently, there are two methods to help settle the resulting disputes: due process hearing and mediation. The due process hearing system can be stressful and frustrating. It is a formal, legal proceeding which requires handing the decision-making power over to a due process hearing officer. The due process hearing officer's knowledge of the situation and the child is far less intimate than that of the parent and educators. Oftentimes, neither party is satisfied with the hearing officer's decision.
Mediation is very different than a due process hearing. So a due process hearing is kind of the end of the road. There's no other options that the parents in the school can see for resolving the issue.
Typically, the due process hearings take a lot longer time than is necessary, so you're interfering with the child's potential education in an appropriate environment.
In mediation, parents and schools can get together early in the process when there's perhaps a disagreement about the correct services that a child's providing.
I believe that mediation is a great way to resolve disputes, in particular because I am an attorney. Initially, I didn't like mediation because since I was hired by my clients to go into court and get something for them, I thought that's what I was supposed to do. My perception of mediation kind of changed, and I started seeing it as a forum that would allow people to negotiate for what they wanted.
Parents many times can bring in issues that a hearing officer is just going to say, this is not something that's even hearable in a due process hearing.
The due process hearing was real, I don't want to say rigid, but it was laid out how they were going to do this.
So you have to trust that we're going to make a decision based upon the information that we've received, testimony that we've gathered, and in accordance with the IDEA law. Whereas mediation, you can work these things out, and you got the professionals being able to banter, if you want to, even back and forth, and reach some type of conclusion that they all can live with. You don't know that you're going to be able to live with the hearing officer's decision.
I've had experience with due process hearings, and that is a very legal proceeding, and it involves the thing one normally thinks of involved in legal proceedings, whereas mediation puts the ball back in the court of those people who are on the front line. That's the parent and that's the district.
In mediation, you have a neutral party to help you achieve a guided decision about what's best for both parties and primarily for the child. In a due process situation, you have someone who's removed from the educational setting making that determination based on the evidence that's presented.
Mediation is a confidential process. What that means is it's between the parties at the table. The parties can't use what gets said at the table in a due process hearing or in a court process.
One of the things with special education mediations that I think is really important is it gives the decisions about the child back to the people that best know the child.
Mediation is not flawless. It can sometimes cause frustration and does not always result in a written agreement. But the frustrations are generally far less than those of a due process hearing. Because the parties are ultimately in control, in the unlikely event that an agreement is not reached, nothing is lost, financially or otherwise. The parties are still free to pursue the dispute through the due process hearing system.
Maybe they didn't reach a resolution on everything. At the very least, they're given the opportunity to be heard. And if it doesn't work, you're at no disadvantage and you're not giving up anything else or any other avenues or remedies that may be open to you.
It's something that doesn't require an enormous amount of preparation. It's very non-threatening. It's an open, guided discussion.
We have found that when parties reach an agreement in mediation, they're more likely to stick to it. They've been a part of the agreement-making process. They feel like it's their agreement. They're invested in it.
What I found is that people have no hesitancy in terms of coming up with agreements that are going to work best for the children.
Requesting mediation is easy. The first step is to complete a request form, which can be found online or in the brochure. You may also contact the Arkansas Special Education Mediation Project to receive a request form. Once the form is complete, just return it, and the program will contact the parties to schedule the mediation.
The mediation request process we've made very simple. Parents may contact the school or an LEA supervisor, or they may contact our program. At that point, we then schedule the mediation. We find a mediator, we find a place to have the mediation, because we go out into the community to do these mediations. We do mediations all over the state of Arkansas. It usually takes about 3 to the outside 14 days to schedule a mediation. The mediation will take a couple of hours, may take longer, it may take shorter, depending on the individual case and the issues.
I think that parents and school personnel need to know that mediation is an easily accessible process and a very viable one for them to be able to express their concerns through.
Mediation benefits all parties involved: parents, educators, service providers, and most importantly, the child. Mediation allows parents to maintain an ongoing and positive relationship with the school system. Often, this process greatly reduces the length of time it takes to get the child back into the positive and productive educational setting that's best for him or her.
Mediation isn't about compromise. It's not about both sides giving in. It's about both sides winning.
We think this program can really be helpful to parents because it's not as time-consuming as dealing with a due process hearing. It happens at a much earlier point in time before disputes get out of hand and do harm to relationships between parents and school districts and others, and it's not as financially costly. In fact, there will be no cost to the parents.
They worked real well with us. We talked about how much time he needed in each different area and what we were working towards. I was real happy with the results of the mediation.
We think that the mediation project is going to also benefit educators because they really want the best education possible for the children. They are invested in the children. They care about the future of these children.
I was extremely happy with the results of mediation. I think we left the meeting with the parent and myself on the same page. We knew where we wanted this child to go as far as its educational growth, and we knew we were going to get there.
Though both parties, school and families, may have a very different position going in, the outcome will be one that is compatible with both of their beliefs and ensuring that the needs of the child are met.
I'm convinced that using mediation is the way to go, that it benefits parents and the district, and obviously then in turn the student.
And I say to anyone who who is thinking about mediation and someone has told them or they have heard that it doesn't work, there's only one time when mediation won't work, and that's if you don't walk in the room.